All right, Chris Dimakos is standing by. Just want to update you, just seeing the story move now. Today was the day we were going to find out whether Marwa Risky was going to be invited back into the Liberal caucus by Charles Milliard, who's now the provincial Liberal leader. Just saw an email go by saying they have decided, or he has decided, not to invite her back. We'll have more on this coming up with Jim Manny, for sure, and David Hertel, who's in for Scott Reed today. Okay, Chris Dimakos is our CJAD 800 legal contributor. Chris, interesting story here today. Common occurrences where employees are taken advantage of by their employers. That's not enough of the story. The rest of the story is they don't even know it. So explain what that means.
Yeah, there's a whole bunch of instances where, when you work and you are told that you're being terminated or being let go, the reason sometimes they give you for that, the amount of money they're giving you as a parting package, sometimes it's overwhelming. And for some employees, they're just dealing with the emotional aspect of not being able to go to work anymore. And sometimes they're not in the right frame of mind to understand, hey, you need to look at this carefully because there might be some things that you're entitled to that they're not giving you. For instance, a very, very common occurrence is when someone works and they're entitled to bonuses. And every year, they get their bonus based on whatever the terms of the employment contract are. And when they get let go, if they're not considered actively employed, so they're not considered an employee at the time when the bonus is being paid out, many employers decide not to pay out those bonuses. And it's important that when you are getting a severance package or you being let go, that the money that they're paying you is not just strictly your base salary. It has to include any bonuses that you would have been eligible for and would have gotten during that severance period as well. Not to mention other benefits. Maybe you have a car allowance. Maybe you have other types of benefits. So one thing that I often have to tell people that ask me about this is, what is your salary when you're working there? And if that's what it is, well, it should reflect that when you're getting your package, your parting package. It shouldn't be bare bones, just your base salary. It should include a lot of the other benefits as well. And that's one way I find many people get cheated out of their bonuses and other types of premiums that they would have otherwise gotten had they still been employed there. So it's very important to get that evaluated and understand, hey, I'm not contesting the number of weeks I'm getting. I'm just contesting the amount that those weeks represent in terms of my salary. I earn more than this, maybe not in base salary, but in bonuses and other advantages that I have that are not reflective on my agreement.
So I want to touch on a couple of these points as well, because I was not aware of this, where employers would conduct a job search for you as the employee after letting you go, because that way they don't have to pay you severance if they end up finding a job for you?
Yeah, that's such an important one. So many times an employee will go to court, file a complaint, and say, hey, I got let go. I shouldn't have gotten let go, and I deserve to be paid accordingly in terms of my notice. How much time? 2, 3, 4 weeks per year of service. And what employers are doing more and more now that they didn't used to do is there's a rule that says, yes, when we assess how much time you need as a severance, the court takes a look at how old you are, what the job market's like, and how much time you need to go from job A to job B, and the employer has to pay for that time frame. But you also have to try and make efforts to find a job to mitigate. We call that mitigation. Well, now what employers are doing is saying, hey, look, I get it that this is an older employee, that they've been here for 20 years, and they otherwise would be entitled to a year and a half of severance. But look how many job opportunities in this field came up right around where they live in the same sector that they never applied for, and they never tried to get another job. And they use this tactic to try and influence the court to reduce the amount of severance that you would otherwise be entitled to. So if you are in that situation and you are with a lawyer and you're going through the process, understand that what you do following the termination, you don't have to go crazy and apply to every job, but you have to have something that's considered to be, satisfactory. You have to make some attempts to find another job if that's what you're doing at the time when you're being let go. Because if you don't, the employer might pull out a list of job applications that were never made,
Oh, I see.
that should have been made,
Right.
that might have reduced the amount of notice you need when you're let go.
Okay. You also have another one here about modifying a contract. Now, I assumed you signed a contract when you started work. That's your contract. And it would seem to me the first thing you would do if your employer said, we need to modify your contract, is find out why, isn't it?
Right. So another very common occurrence is employers are being educated by their attorneys and by their legal counsel, and they say, your contracts, there's some holes here we got to patch up. For example, take the idea of a sales rep. You don't have anything here that prevents a sales rep from working for your competition, and you don't have anything here that prevents them from contacting your clients when they leave. So employer says, well, we got to change that. Let's modify the contract. Let's call them into the office, and let's put a new contract in front of them that they have to sign, and they're going to sign it. And so then the question becomes, well, what if the employee says, I'm not signing this? Well, that's what often ends up happening in court. And what the courts have said is, if you're going to want to modify a contract and you're going to want to get something from the employee that wasn't there when they first started, you have to have some consideration. Maybe you offer a higher salary. Maybe you offer a bonus. Maybe you offer an additional week of vacation. There's got to be something there in exchange, which they call consideration, that has to be present. Otherwise, you run the risk of an employer not being able to enforce that clause because there was never any consideration given. So if you're an employee and that happens to you, it's okay. There's nothing wrong with an employer trying to protect themselves, but that has to come with an incentive for you to sign something that makes your contract even more restrictive in terms of how you're going to be able to get work later on. So really important, and that's happening a lot now with remote work and people being called back, and there's a lot of modifications happening to contracts. Understand that consideration has to be part of that equation. You have to have something that is given to you in exchange for you signing off on this new condition of employment that wasn't there when you started.
Yeah, on the flip side, by the way, I should point out as well, so you talk about an employer, we're talking about who does modify it. If they avoid modifying it, we have people now being called back to work, of course. Things have changed, from the original deal you may have had 3-4 pre-COVID years ago. What happens in a situation like that?
Well, that's a great question because it's happening now, and what courts often look at is say, okay, so you had a contract, whether it was verbal or written, and that was done in the year 2020. And now we're in the year 2026. It doesn't necessarily mean that you can't call people back to work. No, but things might have changed. Your job responsibilities might have changed. What you do, what your position within the company might have changed. Maybe you're handling things that are much higher on the hierarchy and the scale of where you are in the company. And what the law says is, be careful that, what your original contract was, just because you don't have something in writing, doesn't necessarily mean that your employment contract hasn't been modified as a result of just the natural course of what you've been doing at the company. So that's another thing that I strongly urge people to do. If you've been working somewhere for 5 or 6 years, 7 years maybe, and their contract, when you first started, the thing you signed doesn't reflect what you do, doesn't reflect what you're being paid, doesn't reflect what your responsibilities are, it's highly, highly likely that contract won't be the actual agreement that a court would consider to be the one that governs the relationship between you and your employer. There's going to be a new set of terms, albeit verbal, but it's going to represent the true reality of what you do at that company. And that's how employment contracts get changed without even, using a printer or a computer to modify the initial terms.
All right, we leave it at that. Always great advice. Chris, thank you so much. Appreciate it.
Thanks, Aaron.
I'm Dylan Playfair.
And I'm Tyler Smith.
We're putting loneliness in the penalty box by talking to some of our favorite athletes about the importance of friendship.
This is Bromance.
Bromance is brought to you by Charm Diamond Centers, proudly Canadian-owned and operated. Charm has been part of your love stories and bromances for over 50 years.
And you can find Bromance on the iHeartRadio network or wherever you get your podcasts.